correct, and I appreciate all of your patience. Thank you so much.
Well, yeah, you were just asked to be the court reporter less than 20 minutes ago. So, we're very grateful you were able to join us. Ms. Price, I don't know if I've had the privilege of working with you in the past, but as we go through the discussions today, frankly, for some reasons that I'm going to state on the record, it's not going to be an enormously long hearing, but what we'll do is we'll have the lawyers identify themselves. I'll call the case, and then we'll go through some procedures. If at any time I'm mumbling or you can't understand what I'm saying, please stop me. And if at any time, if one of the lawyers is speaking, I'm going to ask that each lawyer identify themselves before they begin to speak each time. And then if you are not able to understand what a lawyer said, Ms. Price, if you can just please interrupt us. Okay. All right. Thumbs up. Good. Okay. I'm going to see if I can get my screen to. Okay. All right. Good morning again. We had started at 10 o'clock. Unfortunately, there were some communication link issues with the previous court reporter who was scheduled to be of assistance to the court and to the litigants. So we'll start again. Today is the day that the court scheduled when it issued its case management order on February 23rd, 2024. And I'd like to have counsel indicate their appearances. Ms. Almirad, you started the batting order last time. If you want to do the same, we can go around, indicate who counsel is and the party that they represent. Please
Sharon
proceed.
Almonroad. I'm sorry. Sharon Almonroad for Mass Torts.
Thanks.
Ted Leopold on behalf of the Mass Torts plaintiffs, Your Honor.
Leslie Kreiger on behalf of Mass Plaintiffs, Your Honor.
Michael Pitt on behalf of Mass Plaintiffs, Your Honor. Good morning.
Morning.
Tom Wan on behalf of Mass Plaintiffs.
Good morning, Your Honor. Dave Dubin here on behalf of Class Plaintiffs.
Jason Thompson on behalf of Class Plaintiffs. Good morning.
Good morning, Elizabeth Fagan for Class Plaintiffs.
Kevin Carlson for the Mass Tort Plaintiffs, Your Honor.
Chris Desmond for the Mass Tort Plaintiffs.
Michael Bonvalenta for the Mass Tort Plaintiffs.
Michael Beam for Mass Tort Plaintiffs, Your Honor.
Daniel Pifko for Bruno Plaintiffs, Your Honor.
Any other plaintiffs?
Nathan Gamble on behalf of the defendants, Your Honor.
Thank you. All right. This is Court's Consolidated Cases 2000, case number 20-0094, MM David Kreiger versus Michigan Department of Environment, Great Lakes and Energy et al. There are 3,000 or so named plaintiffs in the matter. I'm not going to, for expediency's sake, go through the names of all plaintiffs. All plaintiffs' claims are important. The defendants' claims and defenses are important, but out of respect for the amount of time that the parties have committed to this matter, the court will not name all the case numbers or all the individual plaintiffs. This is a status conference which the court scheduled on February 23rd, 2024. At page 13 of the Joint Case Management Order, Roman numeral 7, with regards to status conferences, the court ordered as follows. The court will hold status conferences at 10 o'clock a.m. on the following dates: May 14th, 2024, August 13th, 2024, November 12th, 2024, February 11th, 2025. If a party wishes for a specific issue to be addressed at a status conference, then 14 days prior to the scheduled status conference, the party may file the agenda item with the court. This submission cannot exceed 3 pages, 3 double-spaced pages in length, regardless of the number of issues the party wishes to place on the agenda. If desired, the other party may file a response no sooner than 7 days before the scheduled conference. And a response is also limited to 3 double-spaced pages, period, close quote. The defendants filed an untimely notice of agenda items on November, let's see, sorry. The defendants filed, there's, I believe, Mr. Campbell, what day was it, please?
November 4th.
It's November 4th, 2024. The plaintiffs filed an untimely notice, November 11th, 2024 at 12:36. I would note that November 11th, 2024 was, as it has been since November 11th, shortly after the First World War. So somewhere in excess of 100 years, a federal holiday, also a state holiday, in recognition of what is called Armistice Day initially, because the First World War ended at 11:11 a.m. in Europe on November 11th, 1918. But despite the federal and state holiday, and despite the court's orders, the court received that pleading. Well, I got it this morning. I would note I checked the court's files yesterday at 9:00 p.m. to make sure I was up to speed for the case. But because the second pleading was untimely as well as the first one, the court is not as up to speed as it should be. So what we're going to talk about today is 2 things. And then I'll give some of the parties an opportunity to weigh in. In the attachments to the November 4th submission of the defense, they included at November 1st, 2024, joint mass tort and class action second supplemental answers to first interrogatories. At page 8, 10, 12, 14, 16, and 19 of that submission, they listed as a witness a person named Nathan Gamble or a person named Nate Gamble. There is an attorney who is representing the defendants as lead counsel, whose name, as I understand it, from the submissions is Nathan Gamble. I don't have his P number. He already filed his appearance. And I am wondering, does a plaintiff intend to seek to call an opposing counsel? Ms. Holman wrote, and I know I'm probably mispronouncing your name, and I apologize for the 100th time. I'm just, as my wife has told me, Jim, for a guy who gets elected for a living, you sure are bad with names. And I am, and I apologize for that again. But is it, you spoke for the plaintiffs, mass tort plaintiffs previously. Will you be speaking for them today?
On different issues, on the issue of the answers to the interrogatories, those Mr. Dubin will be speaking on that today. And no apology needed about the name. Everyone gets that wrong.
No. I mean, for heaven's sakes, it's a character flaw that I don't have the discipline to be better at it, and I apologize. Mr. Dubin?
Yes, Your Honor.
Are you intending to call Mr. Gamble as a witness?
I think at this stage, based off the evidence that we have found, we felt that it was prudent to put this out there at this stage. The evidence does indicate that Mr. Gamble was a central figure in the muscle investigation and in the threats of fines and penalties in order to force the water elevations to be elevated. And his involvement going back to basically the beginning of October, November 2018. And while we haven't made a final determination yet to call him for his deposition, we wanted this information out there so as that later on, that when this issue comes to a forefront, it isn't in a way that Mr. Gamble or others will say that he was taken by surprise. I think after reviewing the evidence that we have in our possession, there does appear to be significant involvement by Mr. Gamble in the deliberative process that the Attorney General Office, DEQ, and DNR did in relating to forcing the voice entities to maintain elevated water levels.
All right, thank you. Mr. Gamble, do you wish to be heard? And this is not, I'm not making a ruling. I want to tee this issue up, this thing. This is an issue I want to talk about today. So Mr. Gamble, the floor is yours.
Thank you. This is Nathan Gamble speaking. I have been the attorney for the Departments of Environment, Great Lakes, and Energy and the Departments of Natural Resources for many years. And so correspondence.
May I interrupt just a sec? When you say been the attorney, and I think almost everybody on this case call knows, before I had the privilege of receiving the appointment to serve in the Court of Appeals, I had the privilege to serve the veterans of our state as the director of the Veterans Affairs. And in that capacity, I had our department and agency had an assigned assistant attorney general who provided counsel and advice on just a plethora of issues. Is that what you're speaking to, or what are we talking about?
Yes, that's what I'm speaking to. I'm the assistant attorney general who is assigned to represent these two defendants and has been on matters related to Boyce Hydro for many years. And so it makes sense that my correspondence between the lawyers for Boyce Hydro would be among the documents that we produced because the plaintiffs asked for them. I really can't imagine what factual information I have that non-attorneys don't. So whatever factual information that the plaintiffs want, they can get it from state employees who are not attorneys. So I wouldn't voluntarily sit for a deposition, Your Honor.
Okay. Mr. Dubin, any thoughts on that? And there'll be an order following this conference that this is going to be teed up much sooner rather than much later. But I'd be happy to hear anything that you would like to say before I indicate what's going to happen next.
I appreciate it. I think the evidence that I have seen, the emails that we've seen, indicate that Mr. Gamble was coordinating with DNR, Jessica Mistak, on the muscle investigation dating back into October 2018. Her emails indicate that she was in correspondence in conference with him and dictating that process. The emails also indicate that the dam safety individuals at DEQ were to report to Mr. Gamble to coordinate their interactions with the voice entities through Mr. Gamble. There's also, at the very end, there's the threats by Mr. Gamble of penalties and permit violations that would be reduced if he willingly brought the water back up, and this was in December 2019. Now, what I'm not asking today for a final determination as to whether or not Mr. Gamble should sit or not sit for a deposition. I just wanted it out there that there is a possibility as a witness to these events and a participant in the events that are alleged in our complaints and are reflected in the affirmative acts that we've outlined in our interrogatory responses, that Mr. Gamble has a role in that. Whether at the end of the day that this information can be obtained from other sources, that is something that, you know, we are, as a group, certainly would be open to trying to obtain. I'm not doing this very lightly. I've never, ever sought and put opposing counsel as a witness on any of my cases in 27 years.
Well, I can tell you, I've been a judge for 22 years, except for the 4 that I had the privilege of serving in the previous administration, and I don't know that I've ever seen it. So in a case where it is an illegal malpractice claim where I represented lawyers, obviously lawyers get named all the time in those cases. But no, this, you know, this is serious. This is very serious. The whole case is serious, but the idea that counsel who I think has previously represented in courts of record in these claims, is that right, Mr. Gamble?
Yes, I've been the counsel of record for these cases since they were filed.
All right, so we have counsel of record who has represented a party in multiple courts in multiple phases of litigation. We are 4.5 years after the first complaint was filed, and on November 1st, 2024, for the first time, I see a document that says it pages 8, 10, 12, 14, 16, and 19 that he may be called as a witness. So what's going to happen? I will issue an order after this hearing, which indicates that the plaintiffs will do one of two things. They will file a motion notice indicating that they will strike Mr. Gamble as a witness, or they will file a motion indicating that they intend to call him as a witness. That will be filed by Friday, December 6th, 2024. Mr. Gamble, how long will it take the defense to respond to that? And I understand Thanksgiving, Christmas, New Year's. I want to get this teed up. And Mr. Dubin, will you and your team be able to get some documents, some pleadings to the court where we can have either an evidentiary hearing or at least oral argument on this issue? Is December 6th going to work for you?
I would request a further extension because of the expert reports that are due December 5th, and there are a total of 7 that we are preparing and having filed. And
all right, that's reasonable. Thank you. What about, do you want to go to the 13th or do you want to go to the 20th?
I prefer to have this resolved sooner because of the seriousness of it.
Right, but I also, as I used to say when I was doing settlement conferences, if it were an element on the periodic table, it would be the element unobtainium. And unobtainium is that which is moving this case forward with some modicum on my part. I'm not talking about any lawyers, but on my part, which represents an orderly administration of the process of justice. And I feel that I've woefully failed in that pursuit. So I do want you to have the time. I also want it teed up, but I don't want to set, if you've got 7 extra reports due on the 5th, and then on the 13th, you got to have this thing done. I mean, is that realistic? Is the 20th more realistic?
I think the 20th would be a much better, deadline to submit.
All right. So if we. All right, so. Okay, so if the plaintiffs file on December 20th, Mr. Gamble, the next week it is Christmas, the following week is New Year's week. Can you and your team at the AG's office, because obviously you're going to need to talk with the professional responsibility folks and everybody else, who the experts on lawyer canons that I suspect are in your wheelhouse. Do you think we could reasonably expect to have a reply brief by January 10th?
This is Nate Gamble. Yes, Your Honor. I think January 10th would be fine. And just to be clear, is this something that the court's going to schedule for a hearing right now, or is it going to wait until December 20th to see what the plaintiffs do?
I think it would be prudent to schedule a hearing, and then if we don't need it, then we can adjourn it. But given our history of the time we've shared together since the first of this year, it seems like trying to get a date now would be prudent. And I can tell you, so if we have you on the 10th, any responsive pleading by the 17th, then it seems to me that January 23rd, 2025 as a potential time for on the record oral argument would be what would work for me at this juncture. As I look at my calendar, with the proviso that I do not have insight to what the Court of Appeals courtroom schedules are that week, but usually by the third week of the month, it is exceedingly rare that we're having Court of Appeals oral arguments. So I think January 23rd would work for the court. It with a plaintiff's file by 12/20, defendant's reply or response January 10th. Any final rebuttal pleading by the plaintiffs January 17th. I'd like to do oral argument, calendar oral argument for January 23rd. Mr. Dubin, would that be convenient?
It is.
Mr. Gamble, would that be convenient? And I know obviously you're going to have I don't presume to know who's going to argue the case for your side, but you know, as you know, as you sit here right now, does that sound like those are dates that could work?
I expect I will probably still argue it, Your Honor. But it right now I could only do the 23rd if we did it remotely, Your Honor, in the morning. I have a non-negotiable meeting in the Detroit area that afternoon.
Okay.
So if we could do it remotely.
What about the 22nd? I think being in person would be helpful for me anyway.
I agree. And
24th, 21st.
I could do either the 22nd or the 24th in person, Your Honor.
Mr. Dubin, do you have a preference?
I do not have a preference. Both would work for me.
Mr. Gamble, do you have a preference?
I think Wednesday, the 22nd would be just fine, Your Honor.
Okay. Okay. So, all right. That'll be in the court's order and that I'll issue after this matter is sometime in the next day or two, you'll get an order, but the dates, you can put it on your calendars, counsel who are online. Plaintiff's file by December 20th, 2024. Defendant's reply by January 10th, 2025. Plaintiffs may file a responsive pleading not to exceed 10 pages January 17th, 2025. Oral argument will be January 22nd, 2025. All right. Ms. Almerode, in your submission, which I've already commented on, you did mention something about a mediation order. What's the situation on that?
We had our first session of mediation last Tuesday, November 6th, in front of Judge Rosen. I guess that was last Wednesday, correct that. He suggested that a formal order of mediation be entered, and he suggested he'd had it done in some other cases. And yesterday I received a sample order where he was appointed in another case in the Eastern District. And it indicates, for example, that he's empowered to make the following determinations concerning mediation: the format, the number of sessions, appropriate persons aside from counsel from each side who must attend, including any insurers. I don't believe insurers are applicable here, but who may conceivably have obligations, location, and date.
Okay.
And he suggested it would be helpful if he could have an order similar to that entered here.
Mr. Gamble, have you seen that document from Judge Rosen?
No, this Miss Almonrode's statements are the first time hearing of this.
Okay, so Ms. Almonrode and Mr. Gamble, what I'd like you to, well, let me just say, okay, Mr. Gamble, you have no notice of the contents. Any problems with any of that? I mean, nothing that Ms. Almonrode said that Judge Rosen suggested struck me as, oh my gosh, this is, this, we can't possibly go there. Did anything, and I'm not asking you to commit to it, but did any of that sound, unusual or?
A bit. I think that mediation is governed primarily by the case management order, and just the contents that Ms. Almonrode read out might collide with some of that. So my suggestion is simply that she send me a draft stipulation. We can review it together.
Okay, so Almonrode, if you can send that after we're done today to Mr. Gamble, and see if you can work it out. Today's Tuesday. Get it worked out by Thursday. If you can't work it out, you don't have to send me, we disagree on this, we disagree on that. I just want a copy of what Judge Rosen said. I'm directing the parties to have that presented to me, and I'll issue an order of my own accord. So I don't want to go back and forth on it. So if you can work it out, great. If you can't, send me what Judge Rosen was asking for, and then I will issue an order directly soon thereafter. It won't be, if I don't hear about it until Thursday or Friday, I guarantee you it's not going to be before next Tuesday, because Friday is the opening of the deer firearm season, and I will be in northern Michigan with my family and lots of relatives from all over. And I came down from there yesterday so I could be in my chambers here today with you all. And it's a pleasure and privilege to serve each of you and your clients. But I will be returning to the beautiful northern woods of Michigan, and I will not be issuing a scheduling order for the case when I get back up north for a couple of days. But if you can work it out, great. If you can't, then Ms. Almonrode, just send a letter to Ms. Tomet with a copy to whoever you do on all the other council stuff, and of course to Mr. Gamble, and say, per the judge's instructions at the status conference on November 12th, 2024, here's a copy of what Judge Rosen was requesting, and then we'll move forward with that. Okay. Thank you. Okay. I read in its entirety both of the submissions and all of the attachments, both the ones that I received this morning and the ones we received before this morning. Witnesses. There are 3 attachments to Mr. Gamble's motion or notice regarding witnesses. One is two of them are from October 11th. One is the class representatives, October 11th. One is mass torts, October 11th, and one is joint mass tort class action. I've been a lawyer for 39 years. And all I've done, other than when I was at the agency or working as governor's counsel, is been in courtrooms, in one fashion or another. Private practice, Department of Justice, Navy, circuit court, military courts, you name it. I feel like a broken record when I say a party must know who the other party is going to call as a witness. And an answer that continues to say we are early in discovery and we don't know is unsatisfactory. At 4.5 years after the events took place, of which a very detailed complaint was filed less than a fortnight after the event giving rise to this litigation, that answer is unsatisfactory. It is impossible to either prosecute or defend a case without knowing who the witnesses are going to be. The November 1st, 2024 submission finally comes close to saying, here's what it is. And we give bait stamp responses, we give names, we give individuals, and we move forward like everybody's beloved Detroit Lions. We move the ball down the field. I mean, this is the greatest time in my lifetime to be a Lions fan. I want this case to be a case that every lawyer in this will be able to look back at the completion of your career with pride and say, I did such remarkable work for my clients because I was organized, efficient, direct, and I put the best case forward, regardless of what the result is. We cannot accomplish that together such that the defendants and the plaintiffs all have their day in court if we don't say who we're going to call. So this has got to get fixed. And whether it's you, I know we've extended discovery and I know expert reports are coming, but I am troubled deeply by some of the responses. I will indicate that in the class representatives response of October 11th, there's an actual named individuals saying what they know, what they don't know. That's what I expect to see. But when I see other responses and I direct the party's attention to page 7, second full paragraph of the mass tort supplemental response of October 11th, 2024, that paragraph, it is a non-answer. And I don't know, I am not trying to be rude. I'm not trying to be discourteous. I'm not trying to pick on anyone, but counsel, you are all the best of the best. We've had 4.5 years. We must know who we plan to call. So I expect us to work together to narrow down the I think one witness list, what was the count? It was 2,000 or something, 2,000 witnesses. That just, it's not possible. I mean, I see a response that says state representatives of state agencies. There are literally 50,000 employees of the state of Michigan. Which 50 are we calling? And you've got to know that. I would think, and I get that there's been disputes about discovery, but also when we say in a response that says in response to the FOIA request, we got A, B, and C. What FOIA request? When was it? What request was it responsive to? What's the Bates number? I mean, we're all committed to doing the very best we can in this case and in all of our cases. But we have to have specificity if we're going to be moving this thing to a resolution. Anytime during any of our, well, as I look at the screen, I see several young lawyers. So maybe they're young enough, but you know, I've got a shelf life. I've been a lawyer for 39 years. I mean, I can't, I mean, I constitutionally am limited in the number of years I can serve. Admittedly, much to the shock of my family, I can run again for another full term, but I mean, team, we got to get this going. And I did not, and I do want to ask what the lawyers think, and I'm going to start with Ms. Almenrode. I mean, do I need to appoint a special master?
Your Honor, the October 11 answers from the mass group, those were when we were in court the last time. We agreed that the issue the first issue was whether our individual plaintiffs would be proffering any testimony. And so the due date of October 11 was to address that issue for certain specified interrogatories. And so then in those, we add the supplement. They are essentially the original interrogatories, but the purpose was to add the supplemental answer whether individual mass plaintiffs would testify to any of these matters. And that was added. Let me find an example for you. If you look at page 11, for example, the supplemental response to interrogatory number 6, that was the purpose to add that. So it was not to revisit the other issues at that point in time. We had a November 1 date to answer what we had felt represented as contention interrogatories. And so then on the more recent submission that's on behalf of mass and class involves actually providing the additional information as to the interrogatories and other witnesses, such as state witnesses and so forth. And that's why the November 11 are sparse, because they're for a specific purpose to address that we will not be proffering any mass plaintiffs for the purposes of these interrogatory answers. I believe that class had...
That would have been extremely helpful to have had in a written submission, as I required in my case management order that you all stipulated to before today. I appreciate that. Thank you for sharing it with me. If we could share it in a mechanism, but I still thank you for that. That's helpful. And it should have been replied to when you received the November 2nd or whatever it was submission. We did receive a written submission today from the plaintiffs. It was received today, but it was filed yesterday. None of that information that you've just shared with the court, which is directly responsive to Mr. Gamble's comments in his written submission, were provided to the court. I'm trying to do the best I can, but I need help. I have a finite universe of minutes, and it's the same universe that everybody on this call has. 60 minutes in every hour, 24 hours in every day. And this is a very big case and a very important part of my docket, just like this is a very big case and a very important part of everyone's docket. But it is not my only case. I'm responsible to participate in over 200 full Court of Appeals cases each year. I have a full docket on the Court of Claims. I am honored and privileged, and I am not complaining. But it needs, I need help. And it's the help that's designed in the case management order.
I apologize, Your Honor, for us not responding and also for the late filing of our agenda.
Thank you. What do you think about a special master? Ms. Allman wrote.
I don't think we need one. I don't see a reason for it. I think that we have disclosed information in the recent set of interrogatory answers, and I just don't really see a need for it. Obviously, if the court wants to do that, you know,
No,
obviously.
I know I have the authority to order it, but it's also, I've never had to have one. In 20 years, I've never had to have a special master. And I never had one in any case I was counsel of record on that I have a memory of, but I'm getting old enough that I don't remember everything. My kids tell me that every day. Any plaintiffs count, and Mr. Gamble, I'm going to ask you about your thoughts about a special master, but before I turn to that, I am going to ask if any other plaintiffs counsel who's on the call wishes to weigh in on that. Okay, Mr. Gamble, so I'm giving you a 30-second warning. You know, if you're the coach of the Lions, it'd be like knowing that, you know, whether you're going to have to go for 2 or go for 1. So at any rate, any other counsel wish to amplify as relates to the issue of appointment of a special master? All right. Mr. Gamble, your thoughts, special master?
It's been a challenge from the defendant's perspective to obtain information from the plaintiffs through discovery. And I've sent what I think are detailed messages to plaintiffs' counsel explaining in much more detail than what we provided to the court in the agenda proposal what we need from their interrogatory answers, where we think that they are still lacking, and a similar message in regards to their answers to our request to admit that highlights the problems with them that need to be addressed. And they never responded to that email. So I think that possibly having a special master would be helpful here, to have someone who could be a neutral person who could just, clarify for the parties what the expectations of discovery are and what, just to help move this forward. I'm really trying to avoid motion practice with the court, Your Honor, which is the purpose of why I've sent these long emails to the plaintiff's attorneys, put this on agenda for a status conference, rather than just jumping into motion practice for exactly the reasons the court has noted. So, maybe one suggestion would be to, give the plaintiff 7 days or something like that to just supplement or amend their discovery responses to address.
Okay, you've got the November 1st pleading that you attached to your submission, right?
Yes.
Doesn't that give you some, I mean, that's the most detailed thing I've seen, I think.
I agree, Your Honor. This is Nate Gamble speaking. That's the most detail we've seen in a discovery response by far. But there's still several interrogatories that they essentially do not answer. And I think just giving them an opportunity to just answer the questions would be really helpful. And my thought is, if they still don't, maybe the parties can make written proposals about a special master later this month or something. I'm just kind of off the wall here, Your Honor, but I'm also interested in just moving this forward and getting to a resolution. It's been a challenge from our end.
Okay.
Your Honor.
Your Honor. Go ahead. Ted, go ahead.
Thank you, Mike. Your Honor, I was just going to say, in terms of the goals of moving the case, quicker. I appreciate the special master potentially having that role, but I'm not sure in terms of moving the case that will happen, because one party or the other who is unhappy with the ruling by the special master is going to try and come, it has a right to come to the court, and it's just going to delay, additional rulings and timeliness to get an ultimate result. I think hopefully the parties can, with these additional interrogatories with the government, we can sit down and talk again. I'm not sure there's been a meet and confer specifically about those. I understand the government's long emails, but there's always, without getting into it, there's always two sides to the story, but maybe we should meet again. And if the government is not happy with the ultimate supplemental responses, whatever they may be, then should file an appropriate motion. I mean, sometimes that just has to happen.
Right. Okay, thank you, Mr. Leopold. Mr. Pitt, you wanted to be heard?
Yes, Your Honor. We're 23 days away from the issuance of the expert witness reports. Those expert witness reports are going to create a framework for this case, no doubt. And things
Certainly
will
hope so, my friend.
things will be clarified. I mean, and we will be able to refine our approach to the case based on our expert witnesses who are top-notch people, and they're going to give us some guidance. And so I think we have an issue of timing. If we can wait those 23 days and see how that works, I think there'll be more clarity. And one final comment, Your Honor. Many courts have instructed counsel to designate on their witness lists will call versus may call. And over the years, I have found that to be very helpful. We know who we are going to call for sure. There are for sure people, and there are some maybes. And of course, when we get the expert witness reports, that will further clarify who we believe are the important witnesses. But I think every litigant should be able to designate categories of witnesses, but will call versus may call. And that may help clarify where this case is going.
Thank you, Mr. Leopold. Thank you, Mr. Pitt. Any other plaintiff counsel wish to be heard or ask a couple more questions, Mr. Gamble? No one so indicating. Mr. Gamble, what about Mr. Pitt's thought of a will call, may call?
I mean, I just heard him say that they definitely know who they're going to call. So I would certainly welcome that information. So if they have that information, if they could share that would be ideal.
Let me ask you. Okay, thank you. I agree, and I'll tell you, it's even old dogs can learn new tricks. That's a great one. I'm going to steal that from my playbook. Mr. Leopold.
Your Honor, if I can say, I just am a little concerned. I have done will call, may call for a long time, but usually those lists are made closer to trial. Those are the actual witness and exhibit lists that you do. Here, yes, we are far down the road in terms of time of the litigation or when the incident happened, but not that far down the road, unfortunately, in terms of the litigation. And we can do our best. I just don't. Government comes back and says, "Aha, gotcha. 2 years ago, you gave this list, and may call, will call, and that's your list." As long as we're continue to add to it or delete it from it, that's fine. But I just don't want to be in that situation so far away from trial.
I don't either, and I don't think anybody does. But if the designator is will call, may call, I think what we're trying to do is to alert the other side. Who do you need to depose? And if you don't depose all the may calls, that's sort of at your risk. I mean, if a may call becomes a will call, you file at some point. There's going to be a final trial witness list. But I'm very keen on that idea. I do have a question, but thank you for those concerns. I think they have currency, as all the ideas that have been articulated say. Mr. Gamble, is there in place, and Ms. Alman Road, I'm going to ask your response too, since you seem to be the quarterback of the Discovery team for a lot of this. Is there in place just for example, every Friday or every Thursday, you fill in the blank, once a week, we have a phone call, not a email, not a whatever, but we have a baked into our calendar every single week, unless one of us is on vacation or there's a family emergency, we're going to have a 30 to 90-minute phone call blocked out. Do you have anything baked into your calendar with the opposing counsel to that effect?
No, Your Honor. I'm sorry. This is Nate Gamble. I wasn't sure if you're asking me or Miss Alman Road, but
No, asking you first. Then Ms. Alman, do you agree with that? That there isn't, as we stand right now, we don't have that requirement to pick up the phone for however, at least once a week where we say, okay, here's what we got. This is what happened, Nate. I need that stuff. Or, Sharon, I really got to have this. I mean, do you have that baked into the calendar?
No, we do not.
Mr. Gamble, do you think that that could provide some assistance if you have that as part of what we used to call in the Navy your battle rhythm, that every Thursday at 9 o'clock, I got to talk with Sharon Allman Road and whoever else from plaintiffs about Discovery, mainly focusing on Discovery. I mean, would that be something that would be of assistance?
yes, it would. I mean, whether it's every week, Your Honor, or
No. You can't say, no, you gotta do it. And if it's every week, hey, Sharon, how about them lines? Yeah, they're great. Okay, nothing this week. Bang. But if you do it less, I get every week sounds a lot. I do get that, believe me. But, okay, so Ms. Alman Road, what, every week, every 2 weeks, once a month, once a month isn't enough. I mean, would this be of assistance? Where you're required to pick up the phone and talk to each other, not send emails or texts or whatever.
I think talking to each other would be more effective than the lengthy emails that are not discussed. So I do think a conversation is more effective.
Would you want it once every 2 weeks or once a week?
Once every 2 weeks.
Mr. Gamble, you want once every 2 weeks or every 2 weeks?
Once every 2 weeks, I think would be fine, Your Honor.
All right. Okay. All right. I am not going to sit here and take everybody, any counsel who's on this Zoom conference call. Does anyone have any objection or think it's a bad idea that plaintiffs and defense counsel, and I'm not telling you how to do it. I'm not telling you who's going to be on the call, but that you have an every 2 week call about Discovery issues. Anybody have a problem with that? All right. No one's so indicating, as they say at the church, speak now or forever hold your peace. All right. So, all right. Ms. Alman, would it be an enormous imposition for you to be the person that sends out? I'm going to let you guys figure out what day and time, and I encourage you, pick a day of the week, pick a time of day, and just stick with that. And if Ms. Alman can't cover it for the plaintiffs that week or that bi-weekly period, Mr. Dubin steps in, or Mr. Leopold, or if you really have to hit the barrel, you get Mr. Juan to do it. But, you get somebody in there that, is going to be, talking about your discovery issues. And obviously, I'm just teasing Mr. Juan. I hope it's a good-natured ribbing as a fellow senior member of the bar. But that's, pick a day and time. But Ms. Almerud, since multiple plaintiffs counsel might want to call in, do you mind quarterbacking, how you're going to do it, or?
Not at all. We'll set it up.
All right. I'm going to let good lawyers do good work. You guys figure out, you're going to talk to each other this week yet about the Judge Rosen thing. So you guys get it worked out, and then let's move forward. And I know I've got like the superstars. This is the dream team of litigators, and we should be able to move this forward in a way that is fair and even for everybody, both sides of the V, and move this thing towards, our first part of the bifurcated, situation. All right. Okay. So I'm going to issue an order right now, not right now, but following this conference, and I'm going to go around the table to see what else we want to talk about in a minute. One is going to be about whether or not Mr. Gamble, the plaintiffs, if they're going to, you have to either seek to exclude or indicate they're not going to, Mr. Gamble. And we've gone through that calendar, December 20th, January 10th, January 17th, and an oral argument, January 22nd. We're going to implement a will call, may call edits to the witness list. And we're going to have every 2-week phone call. And you can do it by Zoom if you want, but it's not by email. Email's just, it takes too long to discuss nuanced issues in an email. And we lose the human touch that, and hearing the inflection of opposing counsel's voice, we lose too much. So let's actually communicate with each other directly. Those are the 3 things that I'm going to be issuing. I know there's now a pending motion for reconsideration. When I open the table up, I don't want to hear oral argument on that. Okay. I know it's filed. I've read it in its entirety. And if I require additional briefing, I'll let people know. If I require oral argument, I'll let people know. And I respect the well-stated positions in it. I'll move on from there. What else? Before today, it's now 11:27. We've been on the phone for 53 minutes, 57 minutes. Sorry. Mr. Gamble, what else do you want to address, if anything, while everyone is together?
Your Honor, this is Nathan Gamble. It would be helpful for the court to include in its order a deadline to implement the will call, may call witness list. If the plaintiffs already know who they're going to call at this point, maybe 7 days or so, but just to have a specific deadline would be helpful from our perspective, Your Honor.
And Your Honor, I would like the court to consider, since we're doing the may call, will call at this time so far out, that the parties be allowed to, I don't know if we want to say amend or add to that list as new names appear or parties come up with them. I just don't want to be in a situation where we do one list now and then we do our witness list, and 2 years now, and Mr. Gamble says, well, that person wasn't on the list 2 years ago. Well, that's because we did depositions and names came up and things of that sort. I just don't want to be in a position where we're prejudiced of not adding to names between now and when the final list is done.
And Your Honor, Michael Pitt speaking, I would agree with Ted, and I also would ask that the requirement that we do so take place after we get the expert witness report, because I do believe that it's going to be a resetting of the case. We're going to learn a lot from those experts. And I think that if we could have, let's say, 7 days or 14 days after the expert witness reports to make those designations, I think it would be extremely helpful.
I don't dispute that the expert witness reports are going to inform the analysis and process of the prosecution of the claims or defenses in this case at a very substantial level. The difficulty, if we were to extend it out of, okay, we're going to do a will call, may call list. If we extend it to a week after the expert reports are due, the rebuttal expert reports are not due until January 23rd. And I think what we're, and I guess I'm thinking in terms of, okay, I want a will call, may call list by December 2nd or something like that, let's say. The parties are also encouraged to do a supplemental will call, may call by February 15th. You know, something like that. And understand that this does not waive any other rights that a party may have under the court rules or the law, the case law of the state of Michigan for discovery. I mean, just to, if we know, for example, like I said, in the November 1st, 2024 submission, we have, you know, in my sticky notes on page 4, I say, good identification of documents, introduction of people, you know, so it just seems like there is things that we can do. So I don't know, what are your responses to that sort of thought process, Mr. Leopold, Mr. Pitt, first you were addressing it?
Well, Your Honor, I think that's fine, whatever the additional supplemental date is, as long as it's reasonable to give us time to get through, you know, some discovery documents, things of that sort. As you know, Your Honor, you know, names come up in depositions, and we have to find, you know, maybe do some discovery, and I just don't want to be in a position where when our final list is due that we can't add those people because we're in the midst of doing depositions and things. That's all I'm asking. It's just a fairness issue.
No, and it's for both sides. I mean,
Sure,
Mr. Gamble, if he, you know, continues on as counsel as he has in all the other matters in this case, and he may find somebody that, you know,
absolutely,
gosh, you know, Bill Smith says A, B, and C, and Dr. Edna Jones says X, Y, and Z. I need them. You know, it's possible. Mr. Pitt, did you want to be heard?
I think that Ted's comment is appropriate. I mean, nobody plays gotcha games anymore, and we don't do it. And I know Nate doesn't do it. So let's have a system that allows us to identify who we know for sure who's going to be called. We have many emails that designate some of the key players in this situation, and we can certainly identify those people, but we also need the flexibility of identifying folks as they come up in depositions, and they will come up in depositions. There's no doubt. We'll be surprised by some people who will suddenly appear in this drama, and we need to list them as a will call witness. So
Okay.
I think it's workable, Your Honor.
All right. Mr. Gamble?
Well, first, this is Nathan Gamble speaking. I have no problem, adding some additional time into the procedures here to allow for the naming of additional potential witnesses if discovered that they don't have already. I understand that. To me, that's a different question than just telling the defendants who you know now you're going to call as a witness. And I don't see why the plaintiffs would need much time to do that. I think they already know who they're going to call. It doesn't prejudice them from being able to supplement their witness list in the future as needed. But it seems to me that within 7 days or so, they could just tell us who are the people we know now we're going to call. And then after expert discovery is complete, if they want to supplement, I have no objection to that.
And we can do that, Your Honor. I don't think that's the problem. I think the core issue is we're all working hard. I mean, it's not like we're all separate firms, et cetera. We're all working cooperatively together, but we have experts and we're trying to focus on getting that done over the next few weeks. That's all. So if we can just have until after the reports are done, I don't think, between now and Thanksgiving, not much is going to happen anyway. So that's sort of where we're at.
Okay. All right. Thank you. Okay. All right. Mr. Campbell, anything else you want to address with the court or discuss with plaintiff's counsel while we're together?
No, nothing for me, Your Honor. Thank you.
All right. And the batting order is now going to be where you appear on the magic computer screen in front of me. So the unfortunate luck, Ms. Almonroad again draws the short straw. She's the closest box on my screen. And I think it's because you're almost always, if not always, the first person who's on. So Ms. Almonroad, anything else we should address before we
Yes, one item. We filed the motion, as the court noted, we filed a motion for reconsideration. There are two deadline dates within your order, 45 days and 30 days for us to have cure. Does the court view those as stayed pending the resolution of that motion?
I do not.
If may we address that, and if we may, I'd ask for Mr. Desmond or Mr. Carlson to address that issue, if you're allowing us to address it.
Yes. Thank you, Your Honor. Kevin Carlson for the mass tort plaintiffs. We filed the motion just yesterday, and I appreciate the court's indicating that you've already read the motion, so I won't belabor the point with oral argument as you suggested. Procedurally and administratively, Your Honor, complying with those deadlines to cure is going to be a pretty heavy lift for plaintiffs' counsel and their administrative and support staff. In particular, coming up with proof that each individual who signed a verification had authority in fact to do so. And so we are independently requesting, as part of the motion for reconsideration, 60 days additional time to comply.
Okay. All right. Everybody stay where you're at. I'm going to mute, take the video off. All right, thank you. Mr. Campbell, any thoughts on that? In what Mr. Carlson and Ms. Almero just indicated?
No, Your Honor. I mean, we object to extending the deadline, but I won't belabor that point.
All right, thank you. Okay, thank you. Ms. Almero, anything else?
Nothing further.
All right, Mr. Thompson, you're next on the screen. Anything from you, sir?
Nothing further, Your Honor. Thank you.
Thank you. Ms. Kroger, you're next.
No, Your Honor, thank you.
Thank you. Ms. Fagan.
No, Your Honor, thank you.
Thank you. Mr. Dubin.
No, Your Honor. Thank you.
Thank you. Mr. Carlson.
No, Your Honor, thanks.
I will note that Mr. Carlson wins the most decorative backdrop, and he has the most pictures. He's obviously very proud of his family and friends and stuff that he has.
I got some good ones up there, Judge, if you ever want to see them. Happy to share.
All right. Well, good. Yeah, good. I have, if you come in, you'll see lots of pictures of my wonderful wife, who I adore, of 39 years, and our children. And if you look at my computer, as updated as I can get them are the two pictures of my wonderful granddaughters. So they're all over my computer screen. So one of my team said, I don't know how you concentrate when those beautiful girls are there the whole time. And so, Mr. Carlson, if I'm ever in your neck of the woods, I might stop by. But
Anytime, you're welcome.
all right, Mr. Beam, anything you'd like to add?
Nothing for me, Your Honor. Thanks.
Thank you, Mr. Leopold.
No, Your Honor, although I've been married for 42 years, I'm going to put an Alex Karras photo behind me here, the way you've been talking about the Detroit Lions. To
Yeah,
get a good historical view of our ages, to let you know
yes.
that
I love
feel your pain,
Yeah.
being a Dolphin fan and being in many Super Bowls. So good luck to you this year.
We're excited, and I saw the Lions play with my dad and my younger brother. We're 64 and 62 at Old Tiger Stadium in a snowstorm, and I mean we couldn't have been 10 years old. It was great. It's great to see our wonderful sports teams doing so well in the great city of Detroit, where I grew up, doing so well. So, all right, Mr. Pilko.
Nothing, Your Honor. Thank you.
All right, Mr. Bonvanlanta.
Nothing here, Your Honor. Thank you.
And I also apologize, as I did to Ms. Alm.
Yeah, no problem at all. It's a tough one.
Almost certainly mispronounced your name. Mr. Juan, since I took a shot at the water line at you, so anything you want to share with the court?
No, thanks, Judge. I really appreciate your time today. I would say when I saw my game in Tiger Stadium, I was in high school, so that ages me.
Oh my gosh, high school!
Yes.
Holy cow, you are an old guy, just
Yep.
like
Yep.
a few others. Okay, good. Mr. Desmond, I'm sure you did not see the Detroit Lions play at Tiger Stadium on Trumbull.
No, Your Honor, my first was actually at the Silver Dome. It was a game against the Vikings with a kickoff return for a touchdown by the Lions. So that was my Lions memory at about 10 or 11. So
pretty awesome memory.
Also hooked for life as a result. But
good. Anything else on this case? Anything else, Mr. Desmond?
Oh, no, Your Honor. No, Your Honor. Thank you.
Okay. Mr. Pitt.
All I have to say is I saw many Lion games at Tiger Stadium, and the way the field was set up, the best seats were the bleachers, if you recall.
Oh, okay.
Right.
Yeah.
So you would sit in the bleachers without a back. They had no backs, right? Those bleacher seats were, were just planks of wood. And so I remember sitting on those planks. Yeah, it was very cold.
It was cold.
Yeah, you're right.
At the end of the season, especially.
Right. And the baseball diamond was still there, if you recall.
Right.
So
Right.
right.
It's like, oh yeah, that's where LK line goes.
Right.
Yeah.
Right. So anyway, good memories, Judge.
Yeah, they are. Yeah, they are. Oh God, what a great city. Okay. And then Mr. Razor. Okay. I see a screen, but nobody's replying. All right. Let me just go over a couple of quick things. real quick. Most important person on the call, Ms. Price, anything we need to address for you or any other matters?
Thank you. And no, but thank you all again for your patience earlier this morning.
No, thank you for, yeah, I mean, you came in immediately, so thank you. You literally had less than 15 minutes notice, so we appreciate so much your help on this. All right, court will issue an order memorializing some of the things we spoke about today. I do hope that everyone has a wonderful Thanksgiving with friends and family, and thankful for so many great things in our great country and our great state, and very thankful to be in a great profession that's populated by such outstanding individuals as everybody who's on this call. We're moving through it. We will get to the ability to adjudicate the final claims together, but we've got to work on it together. I don't know if we'll have another hearing before Hanukkah and Christmas and the holidays. If we don't, I wish everyone joyous times, and look forward to continuing to serve each of you and your clients. I know this is an important case for all the plaintiffs, and it's an important case for the state. I would just, no, I'm not gonna, I won't say what I'm thinking about something because it's not my wheelhouse. So, okay. Again, thanks for everybody's time, and I look forward to continuing to serve each of you in this case.
Thank you, Judge.
Thank you, Judge.
Okay,
Your Honor.
sign
Thank
off
you.
now. Okay, out here.